It's time for some Trailblazing Justice. This week we have a special guest, and a very timely one. Erin McKee, co-director of the Immigrant Rights Project, is here. Could a 200-year-old law be used to strip away rights today? And are immigrants the first, but not the last, targets for crumbling civil rights? Join us as we break it all down and find out why what's happening in immigration today could shape the future of justice for all of us. This is Trailblazing Justice, episode 59, recorded Thursday, April 24th, 2025. The cruelty is the point. It's time for Trailblazing Justice, the weekly podcast where we discuss civil and criminal rights in Oregon and beyond. Here's Bobbin.
Welcome back to another episode of Trailblazing Justice. I'm Bobbin Singh, the Executive Director of the Oregon Justice Resource Center. And this week, we are going to be talking immigration with Erin McKee, the co-director of the OJRC's Immigrant Rights Project and co-founder of the Oregon Justice Resource Center. Also here is Zach Winston, the Director of Policy and Outreach, our co-host for the podcast. He may or may not chime in, but he will be here listening and could add some thoughts down the road. But Erin, thanks for joining us. And I know I think we just said you've been on the podcast before, but do you want to give just a brief introduction of who you are and how you kind of came to this work?
Sure. So like you said, I'm one of the directors of our Immigrant Rights Project, and our primary objective in our project is to give advice to public defense attorneys, criminal defense attorneys who have clients who are not U.S. citizens and they need advice on the immigration consequences of the pleas and convictions. So this is constitutionally required advice, and this is the primary objective of the IRP, what we do, our daily work. Prior to this, I practiced immigration law, direct representation, and removal proceedings, family-based immigration, humanitarian benefits like asylum and U visas. And things like that. And so, this has just been a natural progression to this kind of intersection of the criminal law and immigration law. We call it crimmigration.
Yeah, and I think we'll do a follow-up podcast because I believe the last podcast you were on was talking about this crimmigration.
I think so.
I'm trying to reach back into the recesses of my brain and figure out what we've done. But we'll have a deeper conversation just about that work and what's going on here in Oregon. But, in addition to doing the immigrant rights work, you and JJ, who both run the Immigrant Rights Project, are one of the few attorneys that do this work in Oregon. But because of that, your expertise and knowledge is also sort of very valuable in the Immigrant Rights Coalition sort of table that exists. And so not only do you do this work, but you're also sitting at these tables or amongst these coalitions that are doing immigrant rights work here in Oregon, right?
Yeah, that's absolutely right. We have a pretty strong immigrant rights coalition in Oregon, both with community-based organizations and legal organizations. And immigration law itself, it's so huge and varied and complicated that people tend to specialize. So yes, the area that JJ and I work in, this crimmigration area, is highly specialized. And then other areas are highly specialized, asylum work or things like that. And so we have a good community here where we pool our intellectual resources.
Yeah, and I think one of the interesting things is this immigration table, and I think there's a couple of them, but it's significant overlap between all the organizations and groups and advocates that are in them. But it all kind of came together in the past Trump administration, and one of the interesting things that has happened is that infrastructure never really went away. And with the emergence or the second Trump administration, which has felt like a decade, but only, I'm reminded this morning, we're still in the 90th something day. That infrastructure has been able to come back together strong and respond to the things that have been going on with the Trump administration, right?
Yeah, it really has. And, this kind of coming together and falling apart a little bit when it's not needed, that's okay. That's just kind of the ebb and flow of this kind of work. But I would say even since like 2013, when we were gung ho for immigration reform, we thought it was going to happen. We started to get together and pool our resources. And then certainly with the first Trump administration coming together. And now this time with Trump 2.0, I feel like our coalition is really strong. And also just speaking with advocates from other states, people are often just impressed with how strong our coalition and our legal community and our community-based organizations are.
Yeah, and for today's conversation, I mean, well, the whole point is to help explain what's going on federally, nationally,
Mm-hmm.
and how where Oregon is in the context of that. Um, so I think like the first thing I'd like to explore with you is people get confused about what immigration law is. I think because it looks like a criminal kind
Mm-hmm.
of it has all the hallmarks of like a criminal sort of system, thing with
Yeah,
detention and arrests and things like that. But it's not, right? Like immigration law is actually not criminal at all. Can you kind of explain where immigration law kind of sits in the world of law?
absolutely. So you're totally right. Immigration law is technically civil. And again, even though, as you pointed out, even though it looks a lot like criminal proceedings, it is civil, which is why part of the reason why due process rights in immigration proceedings are not nearly as strong as they are in criminal proceedings. Immigration law is also 100% federal, so only the federal government can legislate and enforce immigration law. States can create like immigration adjacent law, but they can't directly legislate. So that's kind of the overarching.
So when you say it's federal, what do you mean by that? Like who's making decisions about immigration law and um because we see like Trump's making a lot of decisions, but
Mhm.
where does the power actually where does the power rest with immigration law? What are the dynamics between the different branches of government?
So the immigration law is rooted in statute, which Congress creates. It's rooted in the Immigration and Nationality Act. And just like with any other area of law or statute, the courts interpret it. And so then we get case law and precedent through administrative decisions and then federal circuit court decisions, appellate circuit court decisions as well. But the executive branch does have a lot of power because immigration is it's kind of tied with foreign policy. And when it comes to immigration, the federal government has what has been called like plenary power. And I used to tell my clients this like, there's no other area of law where the federal government has more power to say who stays and who goes. It does not mean that there aren't limits on that power or that individuals don't have rights. But the starting point is that the government has more power in this area than they do in a lot of different areas. And to that point, the executive branch can create regulations, they can create policy memos, they can issue executive orders as a way to enforce the statutes, the laws, and to like in their role as in their role to enforce the laws, they can kind of prioritize and set different policies.
And so I know, that's why it's important as far as who we elect to Congress, who's elected as president, because you can get this ebb and flow as it relates to
Mm-hmm.
immigration from, every 2 years with Congress and then every 4 years with the president. So is there anything understood to be like a consistent immigration policy, or are we really sort of at the whims of the executive? Is there a culture to kind of create consistency or predictability, or is that sort of all out the window at this point? In what feels like, you know, uh, things change pretty quickly.
Yeah, I mean, right now in this historical moment, it feels pretty chaotic and that things are changing very quickly. And the statute itself is slow to change, but that's part of the problem. It's like part of the reason that the executive branch, we kind of been on a slow climb of the executive branch exerting more and more power and more rulemaking and more policies around immigration, partly because Congress has not meaningfully updated the Immigration and Nationality Act like in a comprehensive, meaningful way since around 1996. And they'll change things here and there, but the statute is very out of date, and it's been kind of congressional inaction has kind of created this space for the executive branch to test the limits of their power. And, Obama did it too. Trump is doing it to a really extreme degree now.
So whenever we hear Congress saying we need comprehensive immigration reform, point that we hear during every election cycle, is that what they're referring to? Is that's what needs to be updated?
Yeah, I mean, when people advocate for comprehensive immigration reform, they are talking about updating the statute, updating the actual laws. That's the basis for everything else.
Okay. And so the laws exist, and basic civics, you have Congress or the legislative branch that creates the laws. As you've already said earlier, the judiciary interprets the laws, and the executive, the president, enforces the law. So when we're talking about enforcement and, the arrests, ICE, all these sort of national apparatuses or apparati being used to effectuate immigration policies, we're talking about the executive at this point implementing immigration law and using these structures. Can you talk a little bit about how that works, and how is it what direction is ICE under? I mean, how are they making their decisions as like an agency?
Yeah, that's a great question. So, I mean, like a starting point, just to get a scope of potential enforcement actions, like there are millions of people in the United States who are removable, right? And historically, the government has had the resources to deport fewer than like 400,000 a year. That is, if they follow the rules, the people get the due process that they deserve. So that's a little bit of a separate question.
So what you're saying is there's like institutional structural barriers and constraints that exist, even if ICE were historically, you're saying, to do their maximum enforcement with the maximal, like with the protections enforced, they could only, and we'll talk about these terms, remove and deport in just a second, but that they could remove or deport only 400,000 individuals a year.
Right. I mean, and essentially the capacity to enforce is much lower than the number of people who could be removed. Like the capacity is very small. And for that reason, prior administrations have typically set what are called enforcement priorities. And so certain categories of people who ICE should prioritize for removal. So instead of just trying to meet quotas or numbers with anyone, they've said that they're trying to go after people with more serious criminal histories or recent arrivals who don't have strong ties to the US yet, or people who pose a national security threat. Like those are common categories of people who in the past have been considered enforcement priorities. Under Trump, we don't really have those enforcement priorities. Like they say they're going after people with serious criminal histories, but they're not, right? Like, I mean, maybe they are going after some of them, but it's not in any kind of predictable way.
Yeah. And that's interesting. And have the enforcement priorities remained fairly consistent from administration to administration, or do they shift from administration to administration, notwithstanding the Trump administration?
Yeah, no, they stay pretty consistent. Like serious criminal history, terrorist ties, and recent arrivals are pretty common.
Okay. So, I just am thinking about, again, the idea of predictability for people who are in this country, for system actors, the immigrant rights community, courts, and trying to figure out, what it is that's coming before them and
Mhm.
who it is that they're trying to assist or support. But I think, like you mentioned, because there doesn't seem to be enforcement priorities by the Trump administration, that leaves um, a wide variety of individuals sort of exposed. And it would suggest that like the immigrant rights or civil rights community is left not understanding where to provide resources and support. Is that fair?
Yeah, I think that's fair. I mean, I think that in practice, ICE is still tends to try to target people with criminal history or certain, or, if they have multiple prior removal orders, ICE would consider them a fugitive. Those would make someone a higher priority. But now, even if ICE is maybe targeting those people, Trump's directives like kind of explicitly say, and then any basically collateral arrests are okay. So like if you're targeting one person, try to scoop up as many people around that target as you can.
Yeah. Yeah. All right. Well, that's helpful. I mean, one of the things, and this is just a little bit of a pit stop in our conversation, but one of the things that we often hear here in Oregon is that we're a sanctuary state. And you said federal immigration law is, in sort of like the federal portfolio, and it's not really the state's prerogative necessarily to enforce or to engage with sort of like immigration practices or policies. But states do enter into agreements with the federal government, right? Like they do have actors that essentially are deputized or act as agents of the federal government to enforce immigration law. But Oregon's different. Can you kind of explain how Oregon's different from in that?
Yeah, so Oregon is considered a sanctuary state. We actually have, I think, one of, if not the oldest, like sanctuary law in the books that's been updated and strengthened in the last few years. And what sanctuary really means is it doesn't mean that ICE can't do their job in that state. It doesn't mean that you are protected from ICE enforcement if you are in that state. What it does mean is, at least in Oregon, is that the state and any, agency or public bodies, public school, etc., in the state cannot use any of its resources for the purpose of assisting with immigration enforcement. And this includes jails and sheriff's offices. ICE will often place a detainer or request information about an individual under Oregon's sanctuary law, particularly the updated Sanctuary Promise Act. Those agencies are strictly prohibited from providing any information or resources unless ICE has a judicial warrant, which they never do. Like if it's a judicial warrant, it's probably a criminal issue and probably the U.S. Marshals are going to be involved, and it's not going to be ICE coming in with that. So it's basically a really strong firewall between ICE and local and state agencies. The local and state agencies also have to report every time they get a request from ICE to the state. So the state's keeping track of that. There are kind of multiple pieces to the sanctuary law, but that's the main part is just a bright line, no cooperation or no helping ICE do their job.
Yeah, and I think as you mentioned before, sort of the capacity limits on the federal government and the capacity restraints on being able to when it comes to immigration enforcement, not having that additional state actors or state apparatuses, apparati, I think that's the plural, right? Being able to assist with immigration enforcement really limits the ability for then ICE to or immigration enforcement to happen. And then also, I think there's a lot of upsides to that, right? Like the community feels safer. You have,
Yeah.
the immigrant community being able to engage with local state actors, whether it's law enforcement, the courts, to be able to resolve issues or to be able to get assistance or support. And that's the thing that's like very dangerous in a moment like this is um, the distrust of government and actors when people need help or support or protections. You have these communities that are unwilling or scared to reach out for that, and
Yeah.
that's I think a lot of the motivation for having these types of laws in place, right?
Yeah, that's 100% right. I mean, these laws make all of us safer. If everyone in the community feels safer, reporting crimes or being a witness or just feel safer in the community, that increases our strength and safety as a community as a whole.
Yeah, I mean, it's just to say that there's probably a number of different motives behind laws like this. And when we
Mhm.
call it the sanctuary law, I think, as you mentioned, it's not meant to be, from just like a moral standpoint of, we're just going to protect immigrants here. I mean, that's part of it. But I think the sort of overarching benefit that it provides to the state of Oregon is that it creates greater stability and safety in these communities because you have then immigrant communities that aren't afraid to interact with state actors, like you said.
Yeah,
So,
yeah. I mean, and Oregon has enough to do on its own. We don't need to
yeah.
be doing the federal government's job for them. We've got our own problems to solve.
True. And, I think we'll try to have like a follow-up conversation on the sanctuary law and what it means here in Oregon. But I think that was a nice overview. But there's a couple of terms that you've mentioned that I just, would like to clarify for folks. And some that you haven't, but I'd like to also discuss. So first, you've used this term remove and deport.
Mhm.
Can you
Mhm.
explain, is there a difference between the two, or what do you mean by those?
Yeah, so in everyday language, people usually say, deportation, someone's been deported. They are technically different terms. So the legal term of art for it is now removal. Someone's been removed. And there are essentially like two different lists. There's a grounds of like inadmissibility and grounds of deportability. All together, they are called grounds of removability. Someone can only be charged as inadmissible or deportable, and it depends on their immigration history, how they might be charged. But it's all done in removal proceedings.
Okay.
So it used to be a long time ago, there were exclusion proceedings and deportation proceedings. The law changed, and now everything's removal proceedings. So most immigration lawyers will say removed, removal, because that's the legal term of art. And deportation kind of refers specifically to specific grounds of deportability or old time deportations, but colloquially they mean the same thing.
Yeah. All right. That's good to know. And then we've I think myself included have often struggled with language around defining sort of the immigrant community. And I know
Mm-hmm.
the term non-citizen is used. We've heard the term disparagingly that, illegals, um, immigrants. So can you kind of walk us through sort of the vernacular of, the language that's being used, or yeah, the vernacular around this population?
Yeah. So the term non-citizen is now the agreed upon legal term for someone who is not a US citizen, as that specific meaning. And I know that some people do take offense to the term non-citizen because they're thinking about the term citizen in a more general way as like a member of the political community. Um, but lawyers and the courts and the press we have landed on the term non-citizen because it's a precise way of saying the person's not a U.S. citizen, and it's a way to avoid the actual statutory term, which is still alien. And so we use non-citizen instead of using the statutory term alien, which is just patently offensive at this point.
And so what do we mean by immigrant? That I know that has like a specific meaning too. And then when people start talking about like illegal, because we still that's still being like thrown around like these illegal people, undocumented people. What do those terms mean? If you can talk, kind of walk through those.
Yeah. So, wait, what was the first term you said?
Immigrant.
Immigrant. Okay. So technically, technically the term there, someone can be an immigrant or a non-immigrant, and they have legal technical terms. An immigrant under the immigration law is someone who's coming to the US or applying to stay and live permanently in the United States. We would say that's an immigrant with immigrant intent. Someone who is a non-immigrant technically is someone who is applying to come or enter the US for a temporary period of time, like a visitor or student or some kind of temporary work visa. So they do have like technical legal definitions. Colloquially, immigrant encompasses like a lot of people, and a lot of people who are US citizens now still identify as immigrants. So it's not a precise term when we're talking about a population who could be at risk for removal, which is anyone who's not a US citizen. And then the other terms you mentioned, I mean, illegals, it's right, like that is also, at least to me, patently offensive. You know, you'll see maybe the slogan like, no human being is illegal. And someone just being present without authorization is not itself a crime, right? Like you could be charged as removal or inadmissible in removal proceedings if you don't have any relief, you don't have a basis to stay here. But mere unlawful presence isn't a crime. And so it's really imprecise and offensive to use the term illegal. Was there another term that you?
Undocumented.
Undocumented. That has been the most widely accepted term if someone does not have lawful status and they're in the US. I think there's debate around that term as well. It's hard to come up with the right language. It's going to feel comfortable to everyone. But when lawyers talk about people who are undocumented, we mean someone who's in the US now and they don't have any lawful immigration status.
Well, that's helpful because I think when you listen to the news or even political conversations, all these terms are used almost interchangeably. And
yeah, and even in like court decisions, like judges who don't really understand the immigration law will like mix up terms as well.
Yeah. So I think it's helpful just to get that clarification. And not to say that any of this will be clarified soon, or people will be talking more precisely, or that we'll find language that's less offensive, but
yeah.
But it's good to know, like, there are these, I think there are specific legal meanings to these, but like you said, colloquially or in sort of the common language, these terms are kind of used interchangeably depending on what people are trying to suggest or what their political bias may be, right?
Yeah.
So I think we've kind of done like a general overview of immigration law and practice and enforcement. Now it's time to get a little bit more substantive.
Okay.
So you've introduced the idea of removal and deportation, or removal legally, but deportation and removal colloquially, like what it is. Can you give us a high-level overview of what that process actually looks like? So if an individual is in the community and for some reason there's a basis to remove them, what is generally, I know it can vary depending on the status of the individual and background, but generally what is sort of the process that happens to that individual if they have law enforcement contact with ICE and ICE picks them up, or Are there other ways that people are identified as removable and sort of pulled into the system?
hmm So, I mean, people can come to ICE's attention in various ways. A very common way is if the person is arrested for a crime, and that's not because the local sheriff's office is like calling up ICE, but when someone is booked for a state or local crime, their fingerprints are taken. That information is automatically shared with federal law enforcement, and that includes ICE. So they might already have someone in their system and can like find someone that way. If someone applies for an affirmative immigration benefit, and they're denied, then they could be referred to removal proceedings, or they're just caught up in some ICE enforcement action. So people can come to ICE's attention in a variety of ways. Once ICE has probable cause to believe someone is removable from the United States,
And
they kind of have. Mhm.
like you said, that's either because they're inadmissible or there's reasons for them to deport them, right?
Exactly, exactly. And those two different lists, inadmissibility and deportability, it's basically if the person has never been lawfully admitted to the US, then they can be found inadmissible, and those grounds are typically broader. And then if the person is inadmissible, they have the burden of showing that they are admissible. And for deportability, that applies to people who have been lawfully admitted. And in that case, the ground of the grounds of deportability are a little narrower, and the government bears the burden. So the key is kind of the burden shifting in the specific grounds. But regardless of what ground they fall under, they come to ICE's attention. They will make a custody determination. So they will issue like a notice to appear, which is the charging document that they'll eventually file in immigration court. And they can just do that. They can just tell someone, hey, we're going to put you into removal proceedings. Here's your notice to appear. Show up on this date. We'll file it with the court. Or they can choose to detain that person for longer. And if they choose to detain that person for longer, the practical route that takes is, they'll arrest the person, they will take them to the nearest like local ICE processing enforcement and removal operations office. A person will stay there usually for less than 24 hours. And speaking specifically for Oregon, because we don't have long-term immigration detention, and then that particular Oregonian would be almost certainly taken to the detention center in Tacoma, Washington, which is the closest immigration detention center.
So, I mean, just going back, because, we're having this really broad national conversation about process and what process is owed to individuals. You mentioned that there's that filing of notice to appear. Is that have to happen in every instance when they're seeking to remove someone?
Eventually, that's basically that is the charging document that starts the court proceeding.
Okay. And is there the ability for ICE to be able to arrest or detain someone without filing that first?
Yeah, I mean, they often do.
Yeah. Okay.
Yeah.
And that's when they are doing like raids or, just, picking up people based on whatever, whether it's race, ethnicity, or they have like a tip, right? Like they'll kind of scoop people up, determine whether or not they're here legally or, or have been, yeah, are here. And then they file a notice to appear at that point.
Yeah, I mean, in that way, it's somewhat similar to criminal proceedings, right? There's probable cause, you arrest the person, and then in that case, like an actual lawyer or prosecutor will file the charges in court. Here it's similar. The person can be detained, probable cause to think they're removable, and then those charges will be filed in court at some point.
So you mentioned court, and I think it's good to talk about what kind of court are we talking about at this point?
We're talking about immigration court. It is not court in, it's nothing like a criminal court. It's not even like a real administrative law court. They just call it a court, frankly. They call them judges, but they're not constitutional judges, like Article 2 or Article 3 judges. But it's immigration court.
And so these are, I mean, who are the people administering these courts or in the position of, like a judge, like you said? And what is the kind of process that people get when they're in immigration court?
So the immigration court, technically it's called the Executive Office of Immigration Review, and they are housed within the Department of Justice. And the kind of process that people get, they're the steps can be similar to criminal court. You have like an initial hearing or master calendar hearing that's similar to arraignment, and you read your rights, and here are the charges against you. And at some point, you have to plead or admit to the charges and allegations. And then eventually, you'll have what's called an individual hearing in the longer trial-like hearing where they will adjudicate the case. But because it's civil and not criminal, the people in removal proceedings are called respondents as opposed to defendants. So the respondents don't have the right to appointed counsel. They have a right to hire their own counsel, but they don't have a right to appointed counsel except in a very limited case if the person has severe mental disabilities and they fit within a specific class of folks. Those people can get attorneys. But everyone else, including children, are not eligible for appointed counsel. And so a lot of people go unrepresented. There are also no rules of evidence in immigration court. So the federal rules of evidence provide like guidance, but we don't have real rules. We don't have like confrontation rights. So like to confront witnesses, which is a common right in criminal proceedings. In a criminal proceeding, the defense attorney would have the opportunity to question the cop who made the report, right? That doesn't happen in immigration proceedings. You don't have the right to question the ICE officer who wrote up, it's the I-213, like essentially the immigration version of a police report. So there are a lot of core due process rights that are in criminal proceedings that don't exist in immigration proceedings.
And so if someone comes, gets arrested or identified as someone that is subject to removal, they appear in this court. There's not much sort of protections to the individual. What I'm hearing is basically the government has a lot of discretion and authority. People don't have attorneys. There's not the similar sort of protections that you see in criminal cases. And so I know there's a lot of advocacy organization or legal organization out there trying to represent people in these. So that's all done pro bono. I mean, how are people getting attorneys? There's clearly not enough attorneys. You're seeing a lot of people go unrepresented. I mean, how is it that people get attorneys? Are they having to pay for them? Or, I mean, is there like a big group of pro bono attorneys assisting folks?
Yeah. So in Oregon, we are pretty unique. I don't know how many others. I know that there are some similar programs in other areas. I don't know if anyone has the kind of really comprehensive statewide program we have here called basically universal representation, which means that, the state or some locality is going to help provide attorneys for people in removal proceedings, and sometimes even for other immigration applications or processes outside of removal proceedings. So we do have that in Oregon. It's basically, the program is called Equity Corps of Oregon. And if someone is, I think it's below 200% of the federal poverty guidelines and they're an Oregon resident, then they can qualify for services through Equity Corps or ECHO. Now, there's still capacity issues. It might take a long time. The program is relatively new and still developing, but that is one way for at least Oregonians in removal proceedings to access counsel.
So otherwise, people are going unrepresented or have to pay for an attorney.
Yeah, yeah, most pay.
Yeah, and it's not cheap, right? I mean, to
No, it's not cheap. I don't even know what the going rate would be now. I think that a lot of immigration attorneys used to charge flat fees, and I would charge pretty reasonable flat fees. But the hard truth is that as things get more chaotic and unpredictable and the laws changing, it's making a lot more work for the attorneys. And so they're having to charge more because there's more work, but at a time when people are particularly vulnerable, right?
I just want to spend a few more minutes on the courts. So I think this is really helps to illustrate, the kind of systems that exist, and in some ways the kind of systems that Trump is looking to bypass with some of his practices. But so the immigration courts, what happens if you get an unfavorable decision? Is there an opportunity to appeal, or
Mhm.
how does that work?
Yeah. So if your application is denied and you're ordered removed, you typically have 30 days to file an appeal, and then it goes to the Board of Immigration Appeals.
And then if you get a unfavorable decision from the board, and who is the Board of Immigration Appeal?
That's a great question. So they are also part of the, DOJ, and they're appointed. I think Trump recently fired. This is like an old Ashcroft move too, like essentially firing all the BIA judges that were appointed by your predecessor. And so you can imagine then how case law and decisions start to roll out. Um, but if somebody is denied at the BIA level, then they can, depending exactly on their case, sometimes there are jurisdictional limits, but typically the person can file a petition for review in the federal appellate um, circuit court. So if it was someone in Oregon and their BIA appeal is denied, typically they could file a petition for review in the Ninth Circuit.
So, just to clarify, what we're talking about is like there's not any state court involvement or federal court involvement really for the overwhelming majority of immigration cases, right?
Right. That's correct. I think it's also just worth noting that at the BIA level, it's not just there are the board members and they can issue precedent decisions, but the attorney general itself, because it's part of the DOJ, the attorney general can just pick any issue or case that they want to out of the big pool of issues and issue a precedent decision. I can't think of any other area of law
Yeah.
where a non-judge, can just
Well,
can
this was
just
my next
make law.
question. I mean,
Yeah.
one of the things that guides state courts and federal courts is the state constitution and the U.S. federal constitution, or the, U.S. Constitution. So the courts are ultimately bound to that and statutes, and they interpret that, and that creates precedent. That creates case law in our legal world, which sets sort of, these foundational kind of interpretations of how the foundation, like how law should be interpreted, and kind of guides other cases with similar facts. So
Mhm.
there's an understanding, like as you're going through the state or federal court system, some sort of like path or guardrails or guidelines that you have, or blueprints to understand how the law is going to be applied to your factual situation. And only the Supreme Court at the end of the day has the ultimate say, whether it's the state Supreme Court or the US Supreme Court. But in the immigration law, which you just explained, is basically on any type of whim, the attorney general can just basically change that, change what that guiding interpretation is or policy is, right?
Yeah.
And that is bizarre, because when you have a situation where you have an attorney general that's a political attorney general in this situation, essentially the way you described it is that attorney general then can reorient immigration policy through
Hmm.
the BIA, like basically what cases are allowed to be successful versus not, and what can be reviewed and not reviewed, right?
Yeah, that's correct. That's correct. The federal appellate circuit at the Ninth Circuit level, there's a little more power back to them after the recent why am I blanking on overturned Chevron, Loper Bright, the
Yeah.
SCOTUS's Loper Bright opinion. I mean, before Loper Bright, it was that the AG could make a decision, and that decision could effectively overrule the Ninth Circuit even. Now that Chevron is gone, and that's terrible for many reasons, environmental, it's not all good, but in the immigration context, it's been helpful because it's taken a little bit of power away from the BIA.
Basically allowing the courts to be able to intervene.
Yeah, basically
Courts.
what it does is the courts were required to defer to the AG and BIA before, even if they disagreed, and now they don't have to.
Yeah. All right. So we have this immigration court system, and it's always fascinating to me how we use like the vernacular of different systems to kind of shield or code or make things sound more official or more unbiased or neutral. But basically, the immigration court system is not really a court system as we traditionally think about it. And it's set up in a way to be very political and manipulated, essentially. Yeah. All right. And what does that do for like immigration attorneys on a week-to-week practice? Like, what are the things you're paying attention to coming out of the immigration courts to help you understand what that means for your clients on a week-to-week basis?
You mean like what?
Like from the BIA, because for us, like we'll look at the Court of Appeals decisions every week from the state of Oregon just to kind of see how they're interpreting criminal laws and how that might apply to cases that we have or to the Oregon Supreme Court. What are immigration attorneys looking at from the immigration court sort of similarly?
Yeah, I mean, we're looking at the BIA decisions. Like I said, like the statutes are really slow to change and they're not going to change, but the BIA interprets the statutes and they can like flip the switch very quickly. And so it's really important to stay up to date on those BIA cases. I mean, immigration judges don't set any precedent, but people certainly, keep their ear to the ground and find out all they can about a particular judge in a particular courtroom because so much of immigration is discretionary. Most immigration benefits, most forms of relief from removal have a strong discretionary element. So even if you meet the statutory requirements, they can deny you even if they think you don't deserve it. And so that's another thing that's why decisions can vary so wildly. You might get like a 99% denial rate out of an immigration court in Louisiana and like a 50% denial rate out of San Francisco. I'm making up numbers, but it's all to say that it can vary wildly from judge to judge and courtroom to courtroom.
And so just one last question before we move on, because I think this is all helpful in being able to set up like the conversation about what's happening nationally. As far as who can be immigration judges, and you alluded to the fact like the BIA people can be fired, who appoints or hires and makes decisions about who are judges in the immigration court system?
Yeah, that's a good question. These judges, again, they're not technically judges. They're not appointed. They are just hired essentially as attorneys to adjudicate these administrative civil matters.
And who hires them? Is it DOJ?
DOJ. Yeah, DOJ.
So is it possible that, in the current environment that DOJ could fire all the judges and rehire them or rehire a different cadre of like judges?
Yeah, we've already, I think that several judges, there's typically a probationary period, and that's like the easiest time to let someone go. I'm sure there are like some technical employment law type limits or part of their contracts that might limit how quickly these immigration judges can be fired. But yes, it's certainly much easier to just fire an immigration judge than to get rid of an actual federal district court judge you need to impeach or something like that.
All right. Well, I mean, I just want people to understand like the heavy layer of the political influence on the immigration. That we're not really talking about unbiased or neutral court system like we think about like at the state level, even though there's a lot of politics usually at play in those, but less so, I think, than you'll find like in the immigration court system. But
Yeah,
all right.
100%.
All right. Now the big questions. Now that we have like a
Okay.
better sense of, you know, what immigration law is, sort of the process, how people can be brought into the system, and what the immigration court system looks like. One of the questions I do have is more around detention centers, but I'm thinking maybe we'll save that.
Okay.
Try to save that for a little bit later in the conversation for a separate recording. But I think the big question I have really is, can you help us understand what's happening nationally? And we hear about this guy, Stephen Miller, all the time. Who is he and why does he matter?
Yeah. Okay. So Stephen Miller is an advisor in the Trump administration. He was in the first Trump administration as well. He is generally regarded as the architect of Trump's immigration policies. And he also has a history of promoting, unsurprisingly, like white nationalist ideas. He is very, very extreme. You may have heard like people describe Trump's immigration policies, or they'll say that the cruelty is the point. And that's really Stephen Miller's specialty. And I'm not one who's like prone to hyperbole, so I'm talking very seriously. Some people in the Trump administration were seeing that they're clearly unqualified, incompetent, and they're causing like all this chaos because they don't understand how the government works and they don't understand how the laws work. But that's not Stephen Miller. He actually understands the immigration law very well, and he understands which levers he can push to inflict like maximum harm and suffering. And so that's why so many of these immigration policies are pulling on like very old laws, very obscure parts of the statutes, very novel and extreme legal theories to reach their ends.
Yeah. For example, can you give us as far as like what's going on right now, I mean, there are distinct efforts kind of happening. We have, the things that's happening with the alleged individuals associated with MS-13. We have the individuals that are alleged to be connected with the Venezuelan gang. And then we have the students that their visas are being revoked and deported, revoked. And in a couple instances, some of those students have been detained for speaking out and pro-Palestinian efforts. But then we've seen like this broader sort of revocation of student visas at academic institutions. So can you help kind of parse out what these differences are? And they're all pointing to different authorities. And I think what you just alluded to, which is these sort of ancient or old sort of laws that haven't been used for creative ways. But I think the one that everyone has been hearing about the most is this Alien Enemies Act. And can you explain what that is, and how that's being applied to at least the Venezuelan individuals that may be connected to the Venezuelan gang?
Right. Yeah. So the Alien Enemies Act is very old. It's from 1798. It has only been employed like 3 times, and all in times of like actual war, like the War of 1812 and World War I and World War II. And what it does is it basically gives the president power to deport certain enemy non-citizens without the usual process.
The process.
So that due process, like notice and like ability for a hearing, and all that jazz. So Trump issued an executive order basing, its authority in this Alien Enemies Act and saying essentially that Venezuelan gang members of Tren de Aragua are invading. This is a predatory incursion. This is an invasion of our country. And I'm invoking the Alien Enemies Act to just summarily deport these people without any process.
Yeah, but I mean, specifically that the gang is not invading this country, but they're doing it on behalf of the Venezuelan government because there's a connection to the government because I think that's how the act can be used, right? Only if a separate sovereign is invading us.
Mhm. It's funny because actually a lot of the language that Trump used, the Trump basically was calling like these criminal organizations, basically saying they are functionally like a government
Oh, okay.
because they have all this control. And, immigration attorneys were all like, great, write that down because we use that in our asylum claims like
Yeah.
all the time trying to argue. So it's a little bit funny, but yeah, that's part of like the reasoning that Trump has used that some of these criminal organizations are functionally
Yeah.
um, like a government. But yeah, so that's like the old ancient authority that he's trying to use to say he can summarily deport these Venezuelans. And that's the substantive issue, right? That's kind of the immigration part. Um, I don't know if you want to get into the procedural, like like why this is a big deal for everyone yet, or what? I'll let you lead that
I
conversation.
do. I mean, but I do want to like because there is, I think, a distinction between what's happening with that group of individuals versus the groups that are alleged to be connected with MS-13, right? Are they using the same justification for?
No, the Alien Enemies Act, to my knowledge, is only being used in the context of train to Aragua from
Yeah,
Venezuela.
that's my understanding.
Um, yeah, other people, I think, when they're trying to link them to MS-13, they, I think they are getting formal removal orders in the first place, right? And so they at least went through some kind of immigration process, whether it was a sham or not.
Yeah. And then individuals from Venezuela are being deported or moved to El Salvador. Is this unusual where you have
Yes.
people being removed to their non-native country?
Yeah, this is wild. This is the idea that, well, it is possible to remove someone to a third country that might not be their specific country of origin. Typically, they have some kind of connection to that third country. At the very least, that third country has to issue travel documents and agree to accept that person. So it is possible to be removed to a third country, but it's typically done only after an actual immigration proceeding. And that issue might be litigated in a removal proceeding. Like the immigration judge is supposed to designate the country of removal, country or countries of removal, if there are options. And so that issue is kind of taken care of in the immigration proceeding.
In that
It's,
instance,
yeah,
those individuals are being removed to those countries like openly in the sense of they're just being removed. They're not being actually removed to a prison and necessarily.
right. No, I mean, this is highly unusual that they're being removed to a third country and directly deposited into. I mean, this is like a maximum
Yeah.
security prison in El Salvador known for human rights abuses. So it's
So we have the Venezuelan or the Alien Enemies Act, and there's a bunch of litigation at the federal level happening around that. I think ACLU National has been one of the lead organizations with that. They're
yeah,
doing like a fantastic job. And
yeah,
I think there's a couple of different issues being litigated. I think one around the procedural issues, which we'll talk about in just a second. But, again, going back to the actual invocation of this law, like, is it even proper? Because the way I've understood it is initially they were saying that Tren de Agua was kind of acting on behalf of the Venezuelan government, which is why they were invoking it. But I think just recently there was some article that came out talking about how all the intelligence agencies and law enforcement agencies in the United States, I think 17 out of 18 or something like that, have concluded that this connection doesn't exist. Or maybe I'm
yeah.
conflating articles at this point, but basically, I think there's an understanding like that this is not the case. So it will be interesting to see how the courts ultimately resolve these issues on the procedural grounds, on the technical grounds, but then also on the substantive grounds as well. And then you have the MS-13 and sort of like the alleged gang affiliations where people are being deported. And then and that I think they're designating them as terrorists, or they designated MS-13 as a terrorist organization. So
Mhm.
does that play into how people are being removed or not really?
I mean, for a lot of those folks, it mostly is getting to whether that might present a bar to relief from removal. So I think a lot of the people who are accused of being MS-13 were undocumented in the first place. So the government doesn't need any extra reason to remove those people. Like, just being undocumented is enough to put them into removal proceedings. But then if they allege these other things, they can bar relief from removal. They can trigger other
I see.
consequences.
Yeah.
Yeah.
All right. And we'll get to the, like I said, the procedural stuff in just a second. So what's going on with the students then? Like, what is that about?
Yeah. So the students, and you kind of mentioned this, like at first, the government seemed to be targeting primarily students with like pro-Palestinian viewpoints. Um, and which, students still have free speech rights. So those are legal
Yeah,
issues to
let's make
be.
clear. The U.S. Constitution applies to individuals.
Yes.
And
Yes.
there's not a distinction as far as like what your status is or, all the Bill of Rights apply to individuals. So yes, First Amendment applies
Right.
to these individuals as well.
Right. But then, like, again, this is where Trump is with those students specifically who they're kind of alleging this. Well, I mean, they're alleging that they're like that they're compromising our ability to conduct foreign policy, that they're having this negative effect on our ability to conduct foreign policy, which is using a part of the immigration statute I didn't even know existed until this moment, right? Like I had to look that up to be like, how could they possibly be charging these people as removable? And so that's another example of just finding all those little levers that already exist in the very unfair immigration law. Um, so that's one group of students. Now it seems like the State Department is just using some fancy algorithm to find any student with any kind of minor, like even traffic infractions, and sending out these like boilerplate scary letters. Your status has been revoked, terminated, and you need to leave immediately. And that's a whole other issue. Now, those students, a lot of them are challenging those and are winning in the court. So that's good. But
On that note, if people do get that email or letter, what should they do?
they should talk to an immigration attorney as soon as possible, right? That the information might not be true, it might not be lawful, or at the very least, there could be not necessarily defenses, but like ways to challenge the revocation and seek reinstatement of their visas or status.
All right. So, I mean, when we're talking about these individuals being targeted and arrested, some of them are being detained. We talked about, there is these sort of two separate pathways. Someone can be given notice that they have to appear in immigration court to, basically defend their ability to remain in the country, or people are arrested and detained. And for Oregon, what that means is because we don't have detention centers here, they're moved up to Tacoma. What is an immigration detention center? I mean, what does that look like? And what is sort of like your knowledge or understanding of what these places are like? And, how do people, what's the experience of people there?
Yeah, so conditions in immigration detention centers are typically very poor. Um, talking to folks who have been in state prison or state custody compared to immigration custody, they will vastly prefer state custody. And you know how poor that system is, right? So I think that can say a lot. Immigration detention centers are also often run by private prison companies. And that is true for the detention center in Tacoma. It's run by the GEO Group. So, whenever profit is the bottom line, then typically conditions are going to be poor for the humans in their care. Medical care is often substandard. Like many of the same problems that plague state prisons also plague detention centers, but there's kind of even less oversight and fewer avenues for relief. Detention centers, immigration detention centers, also weren't like initially designed to be long-term holding, like people can actually end up in those for a year or more litigating their cases, but they weren't really designed for that. So, for example, in Tacoma, it's not like you have individual areas. There's like giant rooms with bunks, right? So,
I mean, I think what you're
yeah,
describing, I think it's basically like a temporary holding facility. It's not meant to be like a prison where,
no,
you
there are
incarcerate.
no programs. There's nothing. Yeah.
And what is sort of the access levels for people at that point once they're in an immigration detention center, like access to their loved ones, family members, lawyers, healthcare providers, those types of supports.
Yeah, typically there is access. I mean, their family can visit people in Tacoma if they're not documented or they're removable, they might not want to, right? And typically legal access is decent. That is one thing that, I mean, lawyers, of course, will raise a fuss, right? If it's not. So people do typically have access to legal counsel if they want it. They have to take those steps. They have to take the initiative to do that, right? Because they don't have the right to appointed counsel. But one thing that makes it difficult, particularly with immigration detention, representing someone in detention, is that ICE can move that person wherever, right? Like the jurisdiction of ICE is the entire United States. So unlike if someone's in state custody, you can be pretty confident if you call to talk to your client tomorrow, they'll still be there. In immigration custody, especially now where the government seems to be just kind of moving people very quickly and secretly, you might kind of lose your client, right? Like have a hard time finding out where they are.
Yeah. I mean, I think there was one example or story of someone that's been in multiple detention centers, and it feels like a lot that the federal government is intentionally trying to obstruct the ability for that person to be able to connect with their attorney and, get support and access to.
Yes. And I think it's not uncommon, that could be retaliation too.
Yeah.
Like, so, yeah.
So, one of the things that we've heard is the federal government thinking about building basically incarceration camps. We saw like the brief attempt to move people to Guantanamo. So what is this about? I mean, is this go back to what you mentioned earlier as far as like capacity constraints on the system to be able to hold and warehouse individuals that are put into removal proceedings or, are trying to be deported?
Yes, 100%. I mean, I think one, I guess, tiny piece of good news is that we were expecting the Trump administration to announce that they were going to invoke the Insurrection Act and try the military to assist more with deportation and detention. And I think the ultimate recommendations from it was probably DHS and DOJ. I don't remember, DHS at least. We're like, we just don't have the capacity. Like they just can't physically make that happen right now.
Yeah, but still on the table potentially.
Yes. Yeah. It's not, the will is there.
Yeah. Just the capacity restraints again
Yeah.
are helping us in this instance. So, we're just over an hour, but like I just wanted to kind of wrap up because this was like a high level overview, and I really appreciate all the information you shared and being in the hot seat and trying to explain all this for us. But what do you think are the big takeaways that we need to be thinking about with everything that's happening to non-citizens or the immigrant community and the targeting and the way in which Trump administration is, and I think this is a good opportunity to talk about like the process that they're trying to bypass. I mean, what is being foreshadowed here? What do you think are the lessons that are like, that we should be learning or should be taking away from this?
Yeah. I mean, I think they're kind of like two different groups I would address with that question. Like for immigrants and people directly affected by these policies, the takeaway is to stay informed and protect yourself, right? Don't trust what the government's saying in the media and correspondence or directly to your face. Like talk to a competent immigration attorney and get good information. For everyone, for all of us, I think we need to understand, or the way I see it is, Trump is testing all of these legal limits in the immigration context, right? Because an unpopular group of people, that's where he is popular on that subject. And if we let him get away with it, there's nothing to stop him from pushing those same legal limits when it comes to other groups, to all of us, to whomever the perceived enemy of the day is, right? These are not just immigration issues. These issues are due process issues, rule of law issues. They go to our core constitutional rights and our system of checks and balances. So, yeah, and that is kind of, you can introduce it to like the procedural issue I alluded to before in the Alien Enemies Act case. There's just the complete lack of due process that the Venezuelans were given. Absolutely no notice and no meaningful opportunity to challenge their classification in this group or to file habeas or do any of that. So that is the most alarming piece to me right now.
Yeah, I mean, I think it's if there's a lot of federal litigation going on, and it's I think a lot of it is focused on some of these like technical and procedural arguments, but the way in which the state's defending this, it very much opens up that power to citizens.
Mm-hmm.
Like,
Yes.
because basically they're saying like once this act is invoked or once these sort of emergencies are declared, whatever it may be, we can bypass this due process, that is fundamental to like our democracy, that's in our Constitution, that prevents the government from just arbitrarily like detaining people. And as a side comment, what I'll say is we're having this national conversation on due process, but in Oregon, we'll have a separate podcast about this, but we've had due process issues here with our current governor and her detaining people without process. That was on the clemency revocations, which we'll have a future podcast about. But it is very scary when you start looking at sort of like, I think what you're saying, Erin, like they're testing these theories and these limits. And if they can win or start chipping away at them, then they can begin to applying them to broader and broader groups of people, not only within the immigration community or immigrant rights or immigration community, but like to citizens. And that is scary.
Yeah, absolutely.
Zach, do you have anything to say or?
No, the only thing I have to say is let's get ready for the midterms. It is a way to send a message and to take at least some options off the table for the administration. So as the director of policy and outreach, it's important that people keep in mind that the midterms are around the corner and it's important to vote.
Yeah.
Here.
One last big topic to kind of end us on. Sorry, this is
I thought it was all done.
this is a big sort of thing at the end. A birthright citizenship. So what is that? I mean, it's big in the sense, but it's pretty straightforward, I think, as far as like what's happening. Do you want to give us like just a quick hit on that?
Sure. So birthright citizenship it's guaranteed by the 14th Amendment to the Constitution. It says everyone born or naturalized in the U.S. and subject to the jurisdiction thereof are citizens of the United States. Full stop. The only kind of recognized exclusion to that are like children of foreign diplomats, right? So, and the Trump administration early on issued an executive order basically reinterpreting the Constitution and saying that unless at least one parent is a U.S. citizen or a lawful permanent resident, LPR green card holder, then that child is not, quote, subject to the jurisdiction thereof, and they're not a U.S. citizen. So he's trying to strip birthright citizenship from everyone unless at least one parent is a U.S. citizen or an LPR. Obviously, like several states have sued. There's a nationwide injunction. One district court judge called it blatantly unconstitutional. Because it is like, this is not an open question. This is a question that the Supreme Court specifically addressed in Wong Kim Ark from, I don't know, Chinese Exclusion Act cases. It would have been like the late 1800s, specifically on this question of the subject to the jurisdiction thereof. Supreme Court clearly found that Wong Kim Ark, a child born in the United States to non-U.S. citizen Chinese national parents, is a U.S. citizen. That has been the law since then. That has been basically codified. Congress has recognized it in statute. It's a clear legal win, hopefully.
Yeah, it's before the Supreme Court now. Well, on a
Yeah.
technical
Actually, isn't it? Right, nationwide injunction, right? That's kind of, I mean, honestly, though, I can't think, I mean, correct me if I'm wrong, Bob, and we haven't talked about this, but like, it seems like a good issue to have the nationwide injunction, have these facts. It's hard to think of a better reason why we would want to have nationwide injunctions than something like this, where if we didn't, and it was just like district by district, people would lose and gain citizenship every time they cross the state line, right? So,
yeah. But, it's hard to know what's going to happen with the current construction of the Supreme Court. I feel like this is a slam dunk in many ways on the substantive issues, but like on this technical issue, who knows? And
yeah, I agree with that. Yeah. I will say the Supreme At all the judges that have looked at the procedural due process issue in the Alien Enemies Act case, at least all the judges that have looked at it have been like, you gotta at least give them due process. Like even Alito and Thomas said due process for that. So I'm grasping on to that.
But the thing about it is, like, when you go back and look at the process that's actually given to people, it's not very much.
Right. No, I know. We're not asking for much. We just want the same, like, happy due process we had before.
Yeah. I mean, and that's the crazy thing about this is that, the amount of process that's being requested is so minimal and so biased anyway that it seems, so ridiculous that there's this even attempt to bypass it. But I guess the last question we'll conclude on is, do you feel hopeful? Do you think there's a light at the end of the tunnel with this? Or are we in sort of a dark period for a while?
I mean, I think both are true. I mean, I think, we're undeniably in a dark period and it's very difficult. But I also think that I do have hope. Things like the really strong language coming from the courts about core constitutional rights and due process, that does give me hope. I also think a lot, and I'm not going to take too much time, but I think a lot about Alexei Navalny. Do you know, he was the Russian opposition leader, and he was poisoned, and he went back to Russia. Anyway, he knew he was going to be imprisoned. He did it because, he believed and he wanted to be a symbol of hope for the people. And he wrote a memoir while he was in prison. And in it, he wrote first of all, he keeps like a lightness to his life that is so admirable given his conditions. And then he also said, I'm hopeful because dictators always fail. They always fail eventually. And I think that's true. And so I hold on to that. And it makes me sad because there's a lot of suffering in the meantime. But I find that to be inspirational and think there's hope there somewhere.
Yeah, I think I'm on the same trajectory with you. I think we're in a dark period. It'll last for a while. A lot of people won't make it through or be severely harmed. But I do think we'll get to the other side of this. I think it's, it's a lot of these national organizations and attorneys and the federal courts that have really, been a backstop to all of this. So I'm just so appreciative of all their work. And like the coalition work or the tables that exist here as far as like the immigrant rights community, like really stepping up, and trying to do what they can to mitigate harm and protect people. So there's
Yeah.
a lot of inspiring things happening. It's hard to see through all the noise, but I think the more and more people engage in sort of like the everyday practice of standing up and advocating for the protection of their neighbor, their fellow community member, the more contagious it gets and the more people feel empowered to it. And I think hopefully that's what we're starting to see with people pushing back, you know.
Yeah.
But I know there's so much more. We just skimmed the surface and all of this. So we'll probably do another recording like in another couple weeks, just kind of digging into some of the issues that we presented here a little bit more deeply, talking about immigration. And, there's likely going to be a lot of shifts and changes in what's happening in immigration law and the immigrant community and, Trump's administration over the next couple of weeks anyway. So be a good time for an update. But thanks, Erin, for being on today. And thanks for listening to another episode of Trailblazing Justice.